I welcome you all to our today's panel discussion, and I'm really happy to have you in our today's session. Let me say something about a few words about Dr. Sanjeev. He is a postdoctoral fellow at Oslo University, where he explores the Rohingya refugee situation through the lens of rights, recognition, and self-reliance. He studied LLB at Brack University, criminology at Oxford University, and earned his PhD as a Commonwealth Scholar from the Warwick Law School. His focus of research centers around the themes within the paradigm of international criminal law, legal history, and politics with specific regards to Bangladesh. Dr. Sanjeev, I welcome again to the session. Dr. Sanjeev and Anupa, are you familiar to each other prior to joining to this session?
No, I never met Anupa
Unfortunately not.
Okay, no problem. I think we have a very agile and young researchers who are gonna sharing their thoughts on a very crucial topic. And when I was reading your bio and all of your short description on the bios and also the abstracts, that was kind of fascination for me that you are working so hard on a very crucial issue of global justice regarding the genocide. And I really, these ideas are really thoughtful and very delightful as well, as because you are working to not only building a block for this, building these academics, as well as you're participating to the process of how we can disseminate this knowledge through this kind of orientation and also this kind of sessions to the greater world. Again, I welcome you all to this session. We are sorry to say that we have a last-minute dropout of one of our panelists from Ukraine, Ms. Stinzana Romashkin, due to some health issues. It would be great if you would have her present into the session. Before jumping into the discussion, let me say a few words about today's panel discussion, some house rule. As we have two discussants in place of three, so we'll have more question period for the two panelists. Dear panelists, may I request you to speak around 20-25 minutes each on your topic. I know you can do that. Meanwhile, I'd request my audience to please note down any of your doubts for the question and answer session, or you can just drop it in the question answer chat box, which will be discussed at the end of our session by our panelists. So, Anupa, Ariel, are you ready for your presentation? Ms. Ariel, can you hear me? Ms. Ariel.
Hello.
Yeah.
I was just sharing my screen. Is it visible?
Yes, it's visible. It's visible. Yeah.
Okay.
Yeah, and it's you can proceed for your presentation, and I wish to speak around 20-25 minutes. Okay. Up to you.
I don't know if let's see. I'll try to conclude it as early as possible, and I would like to present my opinion, like as clearly as possible. We can stop somewhere if anyone is confused, or we can discuss on the matter itself.
Sure. Sure.
So let me begin by introducing myself. My name is Anupa Aryal. I'm currently doing Masters in International Law from South Asian University, New Delhi, India. The topic for my today's presentation is the crime of genocide and determination of dolo specialis for state responsibility, challenges for Gambia versus Myanmar. This is the topic that I'm currently underdoing my dissertation as well. So this is not a concrete outcome of the paper. However, this is what I have read till now, and my views and opinions on this matter. Is it is very important, crucial at this point that this topic of dollar specialis for state responsibility, especially in case of Myanmar, come to an international platform. The discussion rise to international platform.
Well,
I'd like to
I'm sorry to interrupt. May I request again? Is your camera working? Are you because your video is not available?
Oh, I'm sorry. Wait a second.
Yeah. Thank you for your understanding. Oh, that's fine.
Okay.
Yeah. Now.
Okay. I'm so sorry. Yeah. So as you can see, let's begin with the definition of genocide is for Genocide Convention. Article 2 of the Genocide Convention defines genocide means any of the following act committed with intent to destroy in whole or in part a national, ethnical, racial or religious group as such. I'll not go through all this enumerated act because I'm more concerned about the highlighted part of my paper, that is intent to destroy in whole or in part. This definition is verbatim reproduced by ICTY in Article 4, ICTR in Article 2, as well as ICC in Article 6. So what does intent to destroy is, I have used it as dolus specialis in my paper, refers to. Every criminal conduct, every criminal student might know that every criminal conduct has two basic elements. First is actus reus and second is mens rea. Actus reus refers to the act of the crime, whereas mens rea refers to the malified intention behind that act. However, genocide, besides these two acts, requires a third element that is known as dolus specialis, also known as special intent, specific intent, or intent to destroy. So, dolus specialis means that for the objectively related act from Art 1, A, B, C, D, and E, this act requires should be committed with an intent, not only an intent but an specific intent to destroy in whole or in part a protected group as such, in order for them to constitute genocide. So not only killing, not only causing serious bodily or mental harm or imposing measures intended to prevent what constitutes genocide, but these all acts shall be committed with an intent to destroy the entire group as such. Hence, genocide is considered as a crime of double mental element. First is general intent, which can be considered as mens rea, and an ulterior intent, which is dolus specialis. This ulterior intent or dolus specialis is the distinguishable character and determining facet of genocide. However, it is not what intent to destroy specifically is not defined in the convention. ICTY, ICTR, and lately ICC and ICJ in almost every case came up with extremely diverse idea and contradictory outlook on what constitutes dolus specialis or an intent to destroy. Despite this incongruous take, every tribunal, however, has a consensus on one fact: intent to destroy is attributed for individual criminal responsibility. If we think in a general facet as well, if we think in general sense as well, how can a state or entity can have an intent to destroy in a large extent? This question was not raised, or was not in a discussion in an international platform until Bosnia filed case against Serbia in 1998 in ICJ concerning the genocide. It was very difficult, or it was, let's say, it was never imagined to identify special intent of an artificial entity like state. until this case. So, while talking about intent of state, special views have been expressed in terms of difficulty to prove the intent of an state itself, since and it is an individual who actually commits the crime. Nuremberg Tribunal also stated that it is an individual who has a mind or has a rational decision to make, but a state cannot do so, and every act of state is needs to be traced back to individual. Hence, it was never imagined for a state to have an intent. Is Sabas rightly mentioned that it is very difficult or hard to conceive of a state as an artificial entity with specific intent. ICJ in first genocide case, that is Bosnia and Herzegovina versus Serbia and Montenegro, tried to elucidate in this matter. However, it got largely stuck with identifying state responsibility for genocide because it was the most contentious issue to be proved at the first hand. The second genocide case, Croatia and Serbia got enough opportunity to clarify dolus specialis status of state. However, like its preceding judgment, it did little to illuminate the legal uncertainties surrounding the standard of proof for dolus specialis. In both cases, um, court heavily relied on ICTY's decision on genocide to come up with a conclusion of their own. For example, in genocide case first, ICJ heavily relied on Christic judgment and Bolshevik judgment of ICTY to conclude that genocide only, I repeat, genocide only happened in Srebrenica and not in other places. Similarly, in genocide case 2, ICJ based its judgment on Gotovina case, Babik case, Miskik and Martik case to state and to conclude that no genocide happened, or let's say there was no intent to commit genocide in Croatia at large. We'll discuss both the cases in details in this slide. Let's first discuss about the Bosnia and Herzegovina case. That was the first ICJ case. So ICJ in this case, to identify the intent of state, put forward two criteria. It stated that the specific intent to destroy the group in whole or in part has to be convincingly shown by reference to particular circumstance, unless a general plan to that end can be convincingly demonstrated. So, it means that first, you have to find intent of an state in a state plan. You have to see if the state has actually planned to destroy the entire mentioned group, the four mentioned group. And if you cannot find intent in the state plan, then you move toward the particular circumstance to show if the intent was there or not. For this, for the particular circumstance aspect of the crime, ICJ actually referred to patterns of conduct, multiple patterns. However, ICJ said that all these patterns should only point to one specific intent. This is where the problem begins. So, court established by overwhelming evidence that massive killing took place. Victims were in a large majority were member of the protected. They were also systematically targeted. The underlying genocide act, the previous five elements that I have shown, were also met. Despite all this happening, ICJ came to the conclusion that the genocide did not happen based on only a fact that there was no significant intent to prove that genocide happened. Sorry, the atrocities against protected group were not committed. It stated that the atrocities against protected group were not committed with the intent to destroy in whole or in part the group part if such intent is required by the Genocide Convention. Is neither state plan or pattern of atrocities according to ICJ showed intent. So it in its judgment decided that genocide did not happen in Bosnia except for Srebrenica, where Christic case in ICTY already held that genocide did happen. So, based on Christic judgment, it held that genocide did happen in Srebrenica, except that all over Bosnia, genocide did not happened based on state plan and particular circumstances not showing to dolus specialis. In Croatia versus Serbia, it has a greater opportunity and greater chance to decide on the matter of intent of an state. However, it also based, like decided on its based on its previous government. It also pointed out the two stages of determination of intent to destroy. First is state policy, and second is pattern of conduct, similar to genocide case one. So in this also, ICJ clearly stated that pattern of conduct should only point to the existence of such intent. Court was stagnant with only one statement that intent to destroy in whole or in part must be the only reasonable inference. So if such pattern of conduct showed any other inference, then it will not constitute intent to destroy Delos Specialis at large. Despite the fact that Croatia argued for the presence of systematic policy, scale, and consistent nature of crime committed by Serbian force by listing 17 factors for identification, ICC declined all of it, stating that dolus specialis did not existed because all the pattern of conduct could not point to only existence of genocide. This, according to various authors, including Sabas, had said that ICJ have set a very high standard to prove genocide because in none of the case, every pattern of conduct can prove one specific crime. Ethnic cleansing can happen at the same time. Crime against humanity can have act at the same time. War crime also act at the same time. It is not the situation is in 1945 that only genocide did happen is in Nuremberg. There can be state conflict between state parties and non-state parties, and like in the rebel or war, the individual from both the side might die or like have an uglier repercussion in from the both sides. However, ICJ completely dismissed this idea or suppressed this idea and stated that every pattern of conduct should only point to the existence of such intent in a very, very, like purest sense. Let's come. So this is how ICJ identified dolus specialis or intent to destroy in earlier two cases. This intent to destroy question was largely bring into forefront recently when debate surrounding state responsibility for genocide and tracing intent in artificial entity of Myanmar resurfaced after Gambia filed case against Myanmar on November 11, 2019, alleging it of genocide. Unlike the preceding case, ICJ this time has no criminal court. Like in previous case, it has ICTY. ICJ has no criminal court or tribunal judgment to refer in Rohingya case, and it is very difficult to meet the impossible standard of intent that earlier cases have created. I'd like to discuss 5 challenges that ICJ might have in this case, Myanmar, in deciding for the future case. I would like to limit myself here by stating that I'll not be talking about the jurisdictional aspect of it. This is a presumptive that if the case recedes to the merit stage, this might be the challenges in determining intent to destroy or dolus specialis. First is the state policy aspect of it. ICJ in its earlier cases have clearly justified in itself that finding state policy for an on a state for commission of genocide is very, very difficult because a state barely barely acknowledge their policy of targeting an entire group. Rather, they take them rather taking them as a group, they take them as a state rebel or terrorist who is acting against them. This can be clearly shown in Myanmar, is Aung San Suu Kyi as well as state authorities termed the action of Rohingyas is clearance operation meant to eliminate the terrorist threat. They do not acknowledge Rohingya Muslim is a group, like a group, and they are targeting against them. Rather than that, they are seeking it is a clearance operation, meaning to eliminate the terrorist threat from them. So in this situation, the policies can clearly hide with the clever intention of the state. Second is easy defense. ICJ in previous cases have clearly showed how easy it is not is it not to prove genocide. Like in earlier judgment, it is simply possible for the court to easily disprove genocide based on pattern of conduct, not pointing only to genocide. In Croatia versus Serbia, the court found that the fact that act committed by Serb force had the effect of making Croats population flee the territories concerned was not a question of systematically destroying that population, but of forcing it to leave. So the same can be the result in Myanmar case as well, because there is a high number of refugees coming to Bangladesh, and Myanmar has been consistently claiming that it wanted to build this as a Buddhist state, but it do not want to kill the Rohingyas, but they want to like claim themselves as an Buddhist state. So this defense can work on behalf of Myanmar in this case as well. The third challenge is for ICJ right now, or let's say it's a high challenge for Gambia in this period, is rigid consideration and high standard of proof. The high burden of is we know that burden of proof to prove that genocide has been committed in Myanmar goes to Gambia. Is Gambia is the one who filed the case, so there is a higher burden of proof in part of Gambia. Gambia to prove that genocide happened. It is especially difficult when Gambia itself is not the victim of Myanmar genocide. So Gambia at this stage has a higher threshold or higher responsibility to prove that genocide actually happened in Myanmar, and this higher burden of proof can be a very difficult, like consideration for ICJ in claiming or in declaring that genocide did happen in Myanmar. Fourth is fact finding, because ICJ previously, as I said, that ICJ previously highly based on the judgment of ICTY and their fact finding system rather than its own fact finding system. We all know this fact finding mechanism is not superior, neither exhaustive is ad hoc tribunals. Further, Myanmar's reluctance can be additional a problem in determining the evidence of intent. Again, the burden of proof to present a comprehensive evidence lies on Gambia, which itself is a difficult task. Hence, the fact finding make it much difficult for ICJ to determine the intent aspect of it. The fifth challenges that ICJ have in this case is electronic news system and social media conversation. This will be the first time in a genocide case would use social media is proof of special intent. It can be a more painstaking task for ICJ to be considerate about the modern social media status, chats, statements, and conversation, especially when people uses Facebook is their main source of news. And Facebook and Twitter have been an active source of anti Rohingya hate speech in Myanmar. So it will be an interesting for all of us to see this aspect of like ICJ looking into the social media conversation, chats, status, and hate speeches to determine if there was intent or not. But however, this is an additional challenge that ICJ should meet and should consider while deciding the Myanmar case. However, ICJ, unlike its previous judgment, can also opt for a more lenient approach in case of Myanmar judgment, because it has been the previous two decision has been highly criticized, not only by international lawyers, but also by international court judges, like Justice Cansado, who was ICJ judge at the time of Bosnia case, have clearly said that ICJ have kept an higher threshold, which is an impossible standard to meet, and no cases in if this pattern is to be followed for the future cases, then their ICJ will not, will not have a single judgment on genocide in future cases, and ICJ will be proactively working on proving there was no genocide rather than proving state responsibility for genocide. So I think that ICJ should opt for more a lenient approach. These are the few lenient approach that have been, put forward by various authors in international platforms. The first is the mental state of an ruler. ICJ previously though looked into the act of an state organ or state agencies, but ICJ have not looked into the mental state of ruler itself. For example, Aung San Suu Kyi can be a great example to see if
Right.
C is an individual had a mental element or not. Or government can be a strong base to see if they had a strong mental element to commit that crime or not. Second, it
Miss
can be seen.
Ariel, may I request you, sorry to interrupt, I'm really sorry to interrupt.
Yeah, no worries.
I'd request you to conclude your presentation.
Yeah, it's the last slide,
Thanks.
and I only have 3 points. Yeah. So second, this is actually pointed by William Sabas, who is also the defense lawyer of Myanmar in this case. He said that evidence, hateful motive toward the group can be an evidence should be an evidence of genocidal intent. So hateful motive is actually can be seen in Myanmar case quite significantly. So this can be an approach that ICJ can opt for. Third is exclusionary ideologies and religious hatred based on the history. This has been quite frequently argued by these two authors, Campbell and Harf have argued on this matter that exclusionary ideologies actually present in Myanmar case is they have been, refraining Rohingyas from gaining citizenship and all. This can be an evidence of intent in case of Myanmar if ICJ opt for this lenient approach. And fourth of all, experience of refugee can also be a great evidence of intent if ICJ opts to follow it. The recent fact-finding commission have done a great job identifying the experience of refugee in that matter. So ICJ can look into this and correct its eradicate past mistake, and it can move forward with a lenient approach in proving genocide. This is all what I have to say. I end my topic right here.
Thank you very much, Ms. Ariel, for your insightful and very informative presentation regarding a very crucial issue where Bangladesh itself has a stake. And if I mention two important points from your presentation, one is the dilemma, the legal dilemma, or the problems the international prosecutors face regarding the establishment of the criminal intent or the mens rea, or this is you're terming as the role specialist regarding the trial of the perpetrators, and also how that is clearly relevant to the present case of Gambia versus Myanmar. And I really thank you for your insightful and very informative presentation on the topic. We'll come back with more questions and other issues for discuss if you have enough time. Thank you again. Now, I would like to request Mr. M. Sanjeev Hussain to make his presentation on the topic, the principle of legality and genocide in the International Crimes Tribunal Act 1973 from the Bangladesh perspective. As I have gone through the abstract provided from his part, that was it encompasses a lot of issues, and the basic issues I think he would focus is how genocide is termed in section 3, subsection 2, clause 2, as a definition of genocide, how it encompasses also the political groups apart from the 4 other groups defined in Article 2 of the Genocide Convention, and also the Article 6 in the how do you say the Article 6 of the Rome Statute. So without further ado, I would like to request Dr. M. Sanjeev Hussain to make his presentation. Thank you. Up to you, Mr. Sanjeev.
Right. Thank you for this opportunity. I'm very, very, very happy to be here. So before I start telling you about my paper, I just wanted to start off by offering a very quick recap on the scale of atrocities that were committed in 1971, by and large against the Bengali populace, and a little bit about the International Crimes Tribunals themselves. So in 1971, it was the Pakistan Army and its auxiliary forces, particularly Jamaat, Rajakars, Al-Badr, Al-Shams, and these bodies, essentially, these entities essentially collectively perpetrated a range of international crimes against the people of Bangladesh. And according to various estimates, we know that 3 million people were killed, over 200,000 women were raped, 10 million people were displaced and they fled to neighboring India as refugees. Hundreds of prominent intellectuals, poets, scholars, artists, they were abducted and then subsequently they were murdered. So it's in this context that the first International Crimes Tribunal was actually established in March 2010 and under a law called the International Crimes Tribunals Act of 1973. And this law, this 1973 law, was a trailblazing domestic legislative instrument, which was basically framed to prosecute the perpetrators of genocide and other international crimes. And in the years ahead, it is my assessment that the ICTs will be remembered as the last definitive attempt to deliver justice to the victims of genocide and other international crimes that were committed during Bangladesh's liberation war. So with that, having said that, I would like to move on to my paper. So if you look at the title of my paper, I'm sorry, I don't really have any slides, so I'll just speak as long as I can. The title of my paper is basically The Principle of Legality and Genocide in the International Crimes Tribunals Act of 1973. So the principle of legality, it's also known as the rule against retroactive law, and it basically remains a recurring point of tension in the global struggle against impunity. And the ongoing trials in Bangladesh before the International Crimes Tribunals are no exception. And one of the areas of contention surrounding the ICTA, the 1973 law, is the way it basically defines genocide. So the Bangladeshi definition of genocide, it embodies the content and spirit of the classical and widely accepted definition of genocide, which is basically enshrined in the Genocide Convention of 1948. But then, of course, there's a major point of departure. And that point of departure is basically the addition of political groups as a protected group in the Bangladeshi definition of genocide. And critics have basically said that this addition, this inclusion, is a violation of the principle of legality. So what I basically try to do in my paper is that I try to assess whether if the definition of genocide under the International Crimes Tribunals Act of 1973 is compatible with the principle of legality. And to that end, I basically offer in my paper a theoretical and a historical sort of appreciation of the principle of legality. And then, of course, I trace the evolution of the definition of genocide to the year 1971. And then I finally ask whether if the Bangladeshi definition of genocide, which basically includes political groups as a protected group, whether if that definition can be reconciled with the principle of legality. So what is this principle of legality? It's basically, in simple terms, it basically means no crime without a law. It also goes on to mean no punishment without a law. So it's one of the most fundamental tenets of democratic criminal law. And and it's one of the guiding principles of the principle of legality is that the idea of guilt demands consciousness or awareness of illegality. So the principle of legality, it bases itself on the idea that persons who reasonably believed that their conduct was lawful from retroactive criminalization don't really deserve to be prosecuted or punished. So essentially, the flip side is, if someone reasonably senses or believes that what he or she is doing is unlawful from retroactive criminalization, then of course that person does deserve to be prosecuted and punished. Now, if you look back into the past, the principle of legality wasn't always unanimously agreed upon, across civil and common law jurisdictions. And over years, multiple considerations have basically gradually strengthened the foundations and cemented the universal acceptance of the principle of legality. Why? Why? Because we all wanted and saw the importance of, among other things, the fair and foreseeable administration of justice, the need to sort of safeguard citizens against the arbitrary power of the government, and the possibility of excessive judicial discretion. So this acceptance of the principle of legality is reflected in the Nuremberg judgments, the UDHR, the ICCPR, et cetera, et cetera. So the principle of legality has basically transformed over the years from being a principle of justice to being an internationally recognized human right that forms an integral part of our conscience of penal justice that has to be basically observed at all times in national and international tribunals. Now, one important thing to take note of is that despite its pivotal sort of positioning in international criminal law, it's worth seeing how this principle has been applied by various tribunals, international tribunals applying international criminal law. So apart from the ICC, which basically operates prospectively, most judicial bodies that prosecute core international crimes, they, whether if they're doing it at the international level or the local level, they do so with retroactive effect. So if you look at the charter of the International Military Tribunal, if you look at the legal instruments creating the ICTY, ICTR, SCSL, the Tribunal for Lebanon, the internationalized forums of Kosovo and East Timor, if you look at the Iraq Special Tribunal, if you look at the chambers in Cambodia, to statutes like the one in Bangladesh, they've basically enabled and allowed retroactive prosecution of international crimes. And if you look at specifically the provisions of the statutes governing the ICTY and the ICTR, the ones in Yugoslavia and Rwanda, I mean, obviously, they although they claim a rigid adherence to the principle of legality, the approach actually taken in practice is relatively relaxed, and the approach basically bears a resemblance of an element of malleability, the kind that was actually adopted, the kind of approach that was actually adopted in Nuremberg. So this is why their judgments reflect that the principle of legality doesn't really bar the progressive development of the law, provided that that developed law retains the essence of the original crime. So essentially under international criminal law, if you want to international crimes and at the same time preserve the principle of legality, lawmakers basically need to ensure that the law actually that's being used doesn't criminalize conduct that was previously not prohibited by a criminal rule. And then of course, ensure that the law being created reflects customary international law. So I repeat, the principle of legality does not bar the progressive development of the law, provided that the developed law retains the essence of the original crime. So this is basically a question that I want you to think about. The question is, does the Bangladeshi definition of genocide bear or retain the essence of the original definition of genocide enshrined in the Genocide Convention of 1948? Now, let's think about this Bangladeshi definition of genocide. This definition of genocide embodies the content and spirit of the Genocide Convention of 1948, the definition of genocide in the Genocide Convention. But of course, there's one point of departure. It goes beyond the four protected groups, which are basically national, ethnic, racial, and religious groups. And the Bangladeshi definition of genocide actually adds political group as another protected group. And critics basically argue that, political groups were deliberately excluded from the ambit of genocide in the Genocide Convention. And they go on to say that, the efforts to reinsert it into the ICC's definition of genocide was resoundingly defeated. Now, in order to sort of determine whether if Bangladesh's definition to include political groups in the definition of genocide violated the principle of legality, it's really important that we sort of take a walk down memory lane to identify the origins and the development of genocide as an international crime and what the customary international law surrounding genocide looked like in 1971. So I want to start off with a particular resolution which was unanimously adopted by the United Nations General Assembly on the 11th of December, 1946. So that particular resolution is Resolution 96-1. And in that resolution, in addition to national, racial, and religious groups, the United Nations General Assembly recognized political as the fourth protected group. And more importantly, it also observed that genocide could be committed against other groups beyond the four explicitly recognized groups. So it was pursuant to this resolution that the United Nations General Assembly in 1948 adopted the Genocide Convention. However, in the definition of genocide in the Genocide Convention adopted in 1948, political and other groups were basically dropped from the list of protected groups. Now, the question is why? Was political groups dropped as a protected group due to normative reasons? Or was it dropped because of reasons relating to political practicalities or political convenience? Now, my finding in my paper is that the reason why political groups was dropped by the definition of genocide in the Genocide Convention of 1948 was primarily because of political convenience. And this is basically evident if you look at the legislative history of defining genocide in the late 1940s, involving bodies like the UN Secretariat, the Ad hoc Committee on Genocide, the Economic and Social Council, the UN General Assembly, and finally the Convention to the Sixth Committee. Now, it's worth noting that the preliminary draft of the convention, of the Genocide Convention that was prepared by the UN Secretariat, it basically retained political groups. And the first to sort of recommend the exclusion of political groups was the World Jewish Congress, that was sort of really trying to avoid any delay in the acceptance, in the collective acceptance of the Genocide Convention, because they thought that, a delay, it might be induced by sort of variances in opinion as to what constituted apolitical groups. So if you look at the events of April 7th, 1946, you'll see that the Ad hoc Committee on Genocide, it basically convened at a place called Lake Success. And if you look at the text of the new draft of the Ad hoc Committee, it sort of unanimously voted to sort of protect national, racial, and religious groups, and voted 4-3 to protect political groups. So by the smallest margin, the majority actually viewed that political groups do require protection because they were special targets of government repression. And eventually, this draft by the Ad hoc Committee, which included political groups, was passed on to the Economic and Social Council and then on to the UN General Assembly, which then sort of referred it to the convention to the Sixth Committee. And if you look at the proceedings, for instance, of the 75th meeting of the Sixth Committee, again, political groups was retained in the definition of genocide by 29 votes to 13 with 9 abstentions. And you have, for instance, a delegate of Netherlands who was basically saying that, the Nazis had sort of exterminated members of opposition of political parties, and in addition to sort of killing national, ethnic, racial, and religious minorities. And you see arguments in favor of retaining political groups as a political group in this definition. But then, of course, it was at the 128th meeting of the Sixth Committee that Egypt, Iran, Uruguay, for practical reasons, they proposed to sort of reconsider excluding political groups from the definition of genocide. And then, of course, the committee decided by 26 votes to 4 to reconsider this issue. So essentially now they're trying to reconsider whether if political groups should be included in the definition of genocide. Now, and the reason why they wanted to reconsider this issue was because there were some states that felt that the presence of political groups as a protected group would pose as a serious obstacle to the ratification of the Genocide Convention by a large number of states. And it was at this meeting that, the United States, for instance, it moved away from its long-standing position of including political groups. The US delegate, he said that, we still believe in the correctness that, we should include political groups as a protected group. But then, of course, we're willing to delete it from the definition out of a conciliatory spirit in order to sort of ensure the maximum participation of states in the ratification of the Genocide Convention. So, and this is why in the end, ultimately, political groups were sort of voted out of the definition of genocide and the Genocide Convention as a part of sort of like this political compromise, and at the time, political groups was basically voted out. But by 1971, a total of 72 states, including Pakistan, had ratified the Genocide Convention of 1948. So on the face of it, it might seem that Bangladesh had basically violated the principle of legality by including political groups as a protected group, by including political groups in its definition of genocide and under the International Crimes Tribunals Act of 1973. But then, of course, I feel that there are some arguments to suggest that Bangladesh was kind of within its right to include as opposed to exclude political groups. Because, what are some of the experts saying on this matter? So for instance, excluding political groups as opposed to including them has been criticized from a range of quarters. So if you look at Sharif Basuini, he basically described this exclusion as one of the convention. And then, of course, Beth Van Schaak had basically termed this absence as the Genocide Convention's blind spot. And then, of course, Schaak basically maintains that this prohibition on genocide represents a norm of jus cogens, which basically found expression in the original and unanimous General Assembly resolution, which condemned the crime of genocide in 1948. And Beth Van Schaak pointed out that there should be no derogation from that original definition. So this jus cogens prohibition has been expressed further through actions of states like Bangladesh, Ethiopia, Panama, Costa Rica, whose lawmakers specifically included political groups as a protected group when defining genocide in their penal codes. So, and then of course the laws of Peru and Portugal, they criminalize genocide perpetrated against social groups, which offers protection to political groups. So sort of towards the very end, it's true that Pakistan voted against the inclusion of political groups in the definition of genocide, and when at the fag end of the deliberations surrounding the Genocide Convention. However, having actively participated in the drafting of the convention and being fully aware of the circumstances in which political groups was basically dropped from the convention by departing from the spirit of the resolution 96-1, there is sort of scope to doubt whether Pakistan can actually claim that it legitimately believed that trying to sort of destroy in whole or in part, a political group was innocent conduct, undeserving of prosecution. So it's worth keeping in mind Judge Shahabuddin's assertion that the principle of legality doesn't bar the progressive development of the law, provided that the developed law retains the essence of the original crime. And I believe that by granting protection to political groups within the scope of genocide, Bangladesh basically increased the potential for accountability. And by doing so, it made an advancement in the struggle against impunity. So basically in my paper, what I've tried to do is I've tried to demonstrate that although the amount of importance given to the principle of legality has increased over the years, it doesn't really prohibit the prosecution of international crimes through a retroactively applied law. And then, of course, the principle of legality doesn't bar the progressive development of the law, provided that the developed law retains the essence of the original crime. And then, of course, I went on to sort of trace the evolution of genocide as an international crime. And I tried to sort of explain how political groups was always in the minds of those who played a role in the framing of the definition of genocide, but it was ultimately excluded as a protected group because of politically practical reasons. So my conclusion is essentially that the definition of genocide in the International Crimes Tribunals Act did reflect customary international law that existed in 1971. And so the parliamentarians of Bangladesh in 1973, when they were actually framing that law, they weren't really far off the mark when they defined genocide, and that they were well within their right to include, as opposed to exclude, political groups as a protected group. So that's pretty much it from my end. I'm sorry I didn't really have any slides, but yeah, thank you.
Thank you very much, Dr. Sanjeev. Can you hear me? Yeah, I think, yeah, I'm audible. Thank you very much for your terrific and tremendous presentation. And I understand the insight of you already have developed on your academia, and also how you are making deliberation on the specific topic with so many information referring from different parts of the world, different parts of the history. So this is really delightful to hear you. And basic 2 points I have jotted down from your presentation is that how about the background of how and why the inclusion of political group as a protected group under the 1948 Genocide Convention, how it was avoided. And this is really important that you mentioned about the political convenience of the parties at the time not to include, and also the hurriedness of the Jewish Convention for the trial of the perpetrators of that time. So thank you from the bottom of my heart for your excellent presentation. We are very at the end of our time. So just before we conclude, we have a question for Dr. Sanjeev. It says that in terms of the inclusion of political group in the existing ICTBD Act of 1973, what has been the discussion of the lawmakers earlier? Just maybe one or two sentences. I'd request you to.
That's a really good question. So essentially, I've obviously, for the purposes of my research, I extensively read the debates in 1973 when the 1973 Act was actually being framed. Interestingly, the lawmakers didn't really explicitly discuss the inclusion of political groups. So if you go through the text, you won't really find too many instances where they're sort of making a case, like a proactive case, as to why they're including political groups in the definition of genocide. But then, of course, one thing is clear from their deliberations is that they felt that the definition that they were adopting in the 1973 definition, by and large, reflected the spirit of the definition of genocide from the Genocide Convention. So Bangladeshi legislators, they were basically lawmakers, as is stated in the question. They felt that however they were defining genocide in their own law, it reflected the spirit of the definition of genocide in the Genocide Convention of 1948. 48. But did they explicitly refer to why they were including political groups? To the best of my knowledge, they weren't. But then, of course, it's easily understandable as to why they would want to include it. Because if you look at the history of 1971, you'll see that the Pakistan Army and their collaborators, their auxiliary forces, they did specifically, for instance, target
I think,
political groups.
I think,
And we know
Sanjeev, I
which-
think
Yeah.
there's a lot of political struggle from the history as we confront the various narratives from the 1947, since 1947 to after 7, at the very beginning of our liberation war. So the history developed to the process step by step, block after block, the political reasonness and the political exclusion of the Bengalis at the time. These are very, essentials to inclusion of political group as a protected group. Yeah.
Absolutely. And then, of course, if you actually look at the nature of crimes committed in 1971, can we ever deny that the Pakistan Army specifically targeted members of the Awami League? Did they not want to finish off the Awami League? They did.
Yeah,
that is the truth. You don't. So, of course, political groups were targeted. And for that reason, Bangladesh as a sovereign state has absolutely the right to include political groups as a protected group in its own definition of genocide, as long as it sort of bears the essence of the classical definition.
Right. Thank you very much, Mk Tawfiq, and also thank you very much for your excellent presentation. It's a wonderful presentation, Sanjeev Bhai, really great. I think Miss Ariel is not, she left us probably. So she had a question. However, I think we are at the very end of our program, and I would like to thank you, Dr. Sanjeev, and also our other presentation, Ms. Ariel, for joining us in today's program, today's session. This is the month of March and the month of our liberation. So I would like to render my gratitude and also my heartfelt congratulations to the Liberation War Museum and also the Center for the Study of Genocide and Justice to having such a wonderful, wonderful initiative to let the world know, let the globe know what happened in Bangladesh and how we are about our struggles and how we are having our stripes for make the world a better world. So without further ado, I would like to conclude here, and thank you very much and have a good evening to all. Thank you.